Your microphone, Madam Chair. Your microphone.
Call this Zoning Board of Appeals meeting this February the 19th at approximately 6:05 p.m. Meredith, would you please call the roll?
Pennycutt.
Here.
Nicole Henniger.
Here.
Raphael Katz. Linda Thomas.
Here.
Joe Circuzzi.
Here.
Charlotte Burry.
Yeah, here. I would like a motion to approve the minutes of the January 15, 2026 meeting.
A motion to approve the minutes.
Second.
All in favor?
Aye.
Aye.
Aye. Minutes are approved. Welcome to the Zoning Board of Appeals. For those of you that have not ever been here before, this board is comprised of Pompano Beach citizens who serve the city of Pompano Beach without any compensation. To my far right is Scott Reale from Development Services, and to my far left is James Saunders, who is our city attorney that keeps us in line that we don't do anything wrong. And the young lady that runs all this is behind the glass, is Meredith Rollins. For those of you that are petitioners, everything that you have submitted to the city of Pompano Beach has been submitted to every one of our board members, and we have read it. When you are called and your item is called, you will come to that microphone, you will state your name, spell your last name, and your address. And then Mr. Reale will read into the record the city's opinion. After that, you speak. And I want everyone to understand, this is a quasi-judicial hearing. It's kind of like when you go to a courtroom. I need you to speak into the microphone so that everything can be on the minutes. And you will, anyone who wishes to speak tonight, even if you're thinking about speaking, when I ask Meredith to swear you in, I would like you to stand and raise your right hand and swear to tell the truth, the whole truth, and nothing but the truth. Meredith?
Please stand.
For those of you that are going to testify or even think you're testifying, thank you.
Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
Thank you. Okay, item number 1 is a special exception. Pompano Plaza LLC, Planning and Zoning 26-17000001. Mr. Stein?
No, ma'am. Nicholas Noto, N-O-T-O, on behalf of the applicant,
Okay.
Goodwill of South Florida.
Okay. Mr. Reale.
Thank you, Madam Chair. Good evening, members of the board and the public. For the record, Scott Reale with Development Services. In this first case, the applicant landowner is requesting special exception approval as required by section 155-4222P1 of the Pompano Beach Zoning Code in order to utilize the subject property, which is zone B3 for a thrift shop. The subject property is located at the northwest corner of East McNabb Road and South Federal Highway in the Pompano Plaza Shopping Center. Constructed in 1973, Pompano Plaza was developed as a community shopping center serving eastern Broward County. The center was originally anchored by service merchandise and similar mid-century suburban retail tenants. In 2006, Pompano Plaza underwent a significant redevelopment, during which portions of the original structure were demolished to accommodate a larger, modern Publix supermarket, which is approximately 45,600 square feet. The redevelopment marked the transition of the center to its current community-oriented retail format. Today, the center remains a stable commercial node with tenants including Publix, Office Depot, Dunkin', and a Chase Bank outparcel. The applicant, Goodwill Industries of South Florida, proposes to occupy a vacant tenant space of approximately 16,000 square feet, formerly occupied by Marshalls, with a retail thrift store use. The subject property, again, is zoned B3 General Business and is designated Commercial on the future land use map. A thrift shop is permitted in the B3 zoning district, subject to special exception approval pursuant to Section 155-4222P1. The proposed use is consistent with the established commercial character of the shopping center and surrounding area. The proposed thrift store will operate as a single-tenant use as required in the B3 zoning district. Donation drop-offs will occur at the rear of the building within an existing loading zone consistent with Section 155-4222P3 standards. Adequate signage will direct donors to the designated donation area, and no outdoor storage of donated goods is permitted. Traffic circulation within the shopping center is not expected to be adversely impacted by the proposed use. The required parking ratio for a thrift shop, which is 1 space per 300 square feet of floor area, is equivalent to that of the prior Marshall's tenant. Therefore, the proposed use does not increase parking demand beyond existing conditions. Staff notes there is no concentration or clustering of thrift stores within the city. Existing thrift stores include a Pavarello thrift store on North Powerline Road, a Salvation Army thrift store on East Copans Road, and a St. Vincent de Paul thrift store on North Dixie Highway. The proposed location does not create an overconcentration of similar uses in the surrounding area. The zoning code clearly distinguishes between a thrift shop from a pawn shop. Pawn shops are prohibited in the B3 zoning district, while thrift shops are allowed by special exception. The proposed use meets the code definition of a thrift shop and does not include activities associated with pawn operations. Given the site's long-standing use as a multi-tenant retail shopping center, the proposed thrift store represents no meaningful change in land use character or intensity. The reuse of an existing vacant commercial space promotes economic vitality and adaptive reuse without expanding the physical footprint of the center. There are 13 special exception review standards. The applicant has addressed each of these in their narrative, and should the board determine that the applicant has provided competent, substantial evidence sufficient to satisfy those 13 special exception review standards, staff requests the board include the following conditions as part of the order. 1, the applicant shall obtain all necessary governmental permits and approvals, including building and zoning compliance permits prior to commencement of operations. 2, donation drop-offs shall be limited to the designated donation area located on the rear of the building, consistent with Section 155-4222P of the zoning code, and shall include adequate directional signage. And the third recommended staff condition, donations shall only be accepted during the thrift store's normal business hours. The designated donation area shall be clearly posted to prohibit the depositing of goods when the store is closed. That concludes staff's report, and I'm available for any questions.
Good evening again, board members. My name is Nick Noto at the law firm of Bills and Sundberg. Our office is located at 1450 Brickell Avenue, Suite 2300. I'm joined tonight by my colleague, Andrew Shine, as well as several representatives of Goodwill, my client. Included is David Landsberg, the CEO of Goodwill Industries of South Florida, and Mauricio Hernandez, the Chief Operating Officer of Goodwill Industries of South Florida. And I think that's important because, you know, you have the top two executives of this entity here tonight. This is important. We're excited about opening a store in Pompano, so I always want to make sure that I highlight that. I have a brief presentation for you all to walk you through kind of the site and what we plan to do there. I would like to thank Mr. Real for his presentation and his staff report. He's very thorough. I thought that was a very good presentation, kind of teeing this up. We have no objection to any of staff's conditions and are happy to agree to all of those conditions. I always like starting with Goodwill with their mission, because when I first started representing Goodwill, I wasn't aware of the mission. I was aware of the stores. I was aware of the, you know, to me, my wife brings me to a TJ Maxx or a Ross or Marshall's or a Goodwill store, and I see them all the same, right? But I didn't understand what was behind the store itself, which is Goodwill's mission, which is to empower people with disabilities to employment through job training and placement services. And their mission services is what the stores essentially fund and allow to operate. And these are some of their mission services for folks with disabilities in the South Florida community. Those mission services are, again, they're funded not just by the stores, but mostly by the stores. They also do apparel manufacturing. They have some contracts for custodial services, healthcare and laundry services, and some e-commerce. Goodwill is the #1 employer of people with disabilities or barriers to work in Florida. This always gets me. They're the 17th largest employer in South Florida, and they employ 3,000 individuals, 80% of which have some disability or barrier to employment. So all of that to say is this is bigger than just a thrift store, and I do think, you know, what Goodwill does is put out a really professional product in their stores that really is akin to what it's replacing. A Marshall's, a TJ Maxx, it's going to look very, very similar to that. So this is a location, Pompano Plaza, at the northwest corner of McNabb and Federal Highway. And as Mr. Reale kind of walked through, there's 13 different criteria for special exception. We've analyzed each of these thoroughly in our letter of intent, which is part of the record in your backup. I'm happy to walk through any particular one if the board has any questions, but I think that two of staff's notes in its staff report kind of wrap this up nicely. And I know that Mr. Reale just said these, but I'll just reiterate. The proposed thrift store represents no meaningful change in land use character or intensity. The reuse of an existing vacant commercial space promotes an economic vitality and adaptive reuse without expanding the physical footprint of the shopping center. And also that traffic circulation within a shopping center is not expected to be adversely impacted by the proposed use. In fact, this use has the same parking requirement as the prior Marshall's use. This is not a first store for Goodwill. They're currently operating 17 stores in Broward County, 18 in Miami-Dade County. We got approval for a new Goodwill Superstore in Tamarack last year, another one in Fort Lauderdale. So by summer of 2026, they will have 19. I believe this would be 20. That's right, nailed it. Just to show you guys, the board members, what this will look like, we provide some photographs of 2 stores that were recently upgraded. And again, this takes me back to my prior comment. You walk into a store like this and it, you know, to me, and I think to most folks, this looks like your standard, you know, retail outlet store. And they're very clean, they're very well lit, they're very well decorated, they're very well organized. There's no, only like small goods, no like dishwashers or anything of that kind, because I know that sometimes presents a concern for the donation side, but we will also talk about the donation aspect of this facility. So these are just a few photographs of a store that was recently renovated in Miami-Dade County, and another one in Hollywood. As you can see, both look very similar. I always love the picture of the register, because whenever I think of going to one of these stores, it's like all the little widgets you can kind of find on the way out to the register. So I kind of love that picture in the bottom right. So this is our area of work. It's 16,000 square feet on the west side of the existing commercial structure. One thing I want to point out on this slide that I think is really important, because anytime I'm working on a matter like this for Goodwill, everyone's concerned about the drop-off. This site is awesome because it provides a very unique situation in the back of the store, where there's a very wide berth for an existing loading zone with 2 additional rows of parking. So this isn't like your traditional Broward County strip mall with like a very small alley in the back where maybe this donation drop-off could pose some traffic issues. This is the opposite. There's lots of room, there's several rows of parking. This is an ideal location for a Goodwill to have a store with its donation drop-off. This is just showing you an existing photo of where the donation drop-off will occur. You can kind of see how wide this loading area is. We're not even looking at the 2 rows of parking, which would be to kind of the left of where this photograph was taken. And here's our kind of mock-up floor plan. You can see on the top left of your screen, is where those two donation doors are that I just showed you on the photograph of the rear of the facility. To the right of that is the pre-sales area. So Goodwill doesn't just take the goods that are donated at this particular store and put them out on the shelf. They have a very sophisticated operation where things are moving, I think, every 3 days. Every 3 to 5 days, inventory is circulating through their stores, so the consumers have a new experience every time they come. So that's what a lot of that pre-sales area is in the back, is getting new goods in from other Goodwill stores, and getting some of the goods in this store out to those other Goodwill stores. So it serves several purposes, but on the left side is the donation drop-off area. And you can also see, obviously, kind of the floor plan for the store. Here's a couple just renderings of the new design and what we expect this store to look like once we make all of our tenant improvements. And same with the donation center. And that is it. I am here and happy to answer any questions that you may have, and I thank you very much for your time.
Thank you. Does the board have any questions? Is there anyone in the audience that wishes to speak on behalf of this petition? Have you been sworn in? Okay. Is there anyone wishing to speak in opposition to this petition? Hearing none, public hearing is closed. Again, does the board have any questions? If not, I would entertain a motion.
I do have a question. As it relates to special exception review standard number 11, which is that the applicant fulfills a demonstrated need for the public convenience and service of the population of the neighborhood for this special exception use. I didn't hear anything with regard to that, or maybe I missed it.
Sure, I'm happy to answer that directly. So there's a few things. One, I think it's a commercial plaza. There's a vacant large retail space there, 16,000 square feet. I think any sort of vacant space in a prominent commercial plaza on a prominent corner is not great for the community. I think any activation of that space provides necessary economic vitality to the neighborhood. I will say that Goodwill provides a unique answer to this question in that they're going to create 20 to 30 jobs for residents of the city of Pompano Beach. And even more special than that is because their whole mission focus is helping folks with disabilities, the fact that they'll be in this community means that there is a kind of a beacon for folks in this very community that may have family members that have barriers to employment and otherwise have struggled to find resources to help them. Now they have a Goodwill here that not only may employ them in this very store, but can take advantage of all their mission services close to home rather than having to travel previously to another location.
Okay. I might say something. This area that you want to put the Goodwill store in is where Tuesday Morning used to be. Is that correct? It's at the total west end of the plaza. And Tuesday Morning was a place where you could get things like this that you have in Goodwill, plus not refrigerators and stoves and everything, but clothing, pillows, whatever. And I think that building has been vacant for quite some time. The reason why I know is I get my nails done in that
There you
plaza,
go.
so I know it real
It's
well.
important.
Thank you.
Like to make a motion?
Yes, please.
In Planning and Zoning Case 26-1700001, I move that we find there is competent and substantial evidence in the record that all the requirements for granting special exception have been met, and that we grant the special exception subject to the 3 conditions requested by staff.
Second.
It's been moved and seconded. Any comments from the board? Meredith, would you please call the roll?
Penny Cutt,
Yes.
Joe Circuzzi,
Yes.
Nicole Henniger,
Yes.
Raphael Katz,
Yes.
Linda Thomas,
Yes.
Charlotte Burry.
Yes.
Thank you very much. I hope you guys have a great night.
You have a great night, too. Item number 2 is a special exception for 951 Southwest 12th LLC, Planning and Zoning number 26-17-000002. Daniel Gabriel?
Andrew Shine.
Okay, Andrew. You have to understand that that's the name that they put on my agenda, so I'm sorry I called you by the wrong name.
That is completely okay.
Okay. Would you please state your name, spell your last name and address?
Yes, Andrew Shine with Bills in Sunburg. Last name is Schein. Address is 1450 Brickell Avenue, Suite 23.
Ms. Reale.
Thank you very much. Again, for the record, Scott Reale with Development Services. The applicant landowner is requesting special exception approval as required by Section 155-4228A1 of the Pompano Beach Zoning Code in order to utilize the subject property, which is zoned I-1, for outdoor storage as a principal use. The subject property is located along the west side of Southwest 12th Avenue, which is known as South Andrews Avenue, between Southwest 8th Street and Southwest 12th Street in the Andrews Industrial District. The subject property currently has 2 open code enforcement liens, and with us tonight is Mario Sotolongo, who I'd like to, after I read my staff report, speak to the code enforcement and liens associated with the property. They are included in the backup for informational purposes. Any outstanding code enforcement or liens should be resolved in accordance with city requirements and do not in and of themselves preclude consideration of the requested special exception. The property maintains an active city-issued business tax receipt for outdoor storage and import-export operations under the business name of North Atlantic International Ocean Carrier. I understand operations have ceased. The existing business activity reflects a long-standing industrial use pattern consistent with the surrounding Andrews Industrial District. On May 20th, 2021, the Zoning Board of Appeals granted approval of a special exception for outdoor storage as a principal use under P&Z Case 21-17000006. That approval was expressly tied to Site Plan 21-12000011, which depicted a specific site layout, circulation pattern, and development configuration. Since that approval, the applicant has submitted a new site plan application. That's P&Z 25-12000039, proposing a significantly different site design, including the addition of 2 warehouse buildings in conjunction with outdoor storage areas. Due to the material differences between the previously approved site plan and the currently proposed development, staff determined that the prior special exception approval could not be carried forward and that a new special exception review is required to allow the board to evaluate the proposed outdoor storage area within the context of the revised site layout. The current site plan application, again, 25-12000039, was reviewed by the Development Review Committee on December 19th, 2025, and yesterday, February 18th, 2026. Final compliance with the applicable development standards, including buffering, screening, circulation, and operational requirements, will be evaluated through the site plan review process. The subject property is zoned I-1, which is general industrial, pursuant to Section 155-4228A1 of the zoning code. Outdoor storage as a principal use is allowable within the I-1 zoning district, subject to special exception approval. The applicant's request is therefore eligible for consideration by the Zoning Board of Appeals. The subject property is located within the Andrews Industrial District, an established industrial area characterized by truck-oriented manufacturing, wholesale, storage, and vehicle-related uses. All surrounding properties are zoned I-1, and the existing uses include truck and car rental facilities, manufacturing, wholesale operations, recreational vehicle sales, and truck services. The proposed outdoor storage use is consistent with the prevailing land use pattern and industrial character of the surrounding area. Again, there are 13 special exception review standards which the applicant has addressed in their narrative. And should the board determine that the applicant has provided competent, substantial evidence sufficient to satisfy those 13 review standards, staff requests the board include the following conditions as part of the order. 1, prior to commencement of the outdoor storage use, the applicant shall obtain and maintain all required governmental permits and approvals, including but not limited to final site plan approval, building permits, zoning compliance permits, a zoning use certificate, and a city-issued business tax receipt. 2, development and operation of the site shall be in substantial compliance with the site plan submitted with this application and P&Z number 25-12000039. Other than minor deviation, any significant deviation shall require a new special exception application for outdoor storage as a principal use. The special exception approval is limited to outdoor storage as a principal use as defined in section 155-4228A2 of the zoning code and shall not be construed to permit a junkyard, a salvage facility, vehicle sales, rental, or display use. 4, all outdoor storage areas shall comply with the perimeter screening, fencing, and other buffer requirements of section 155-4228A3A and applicable provisions of chapter 155, including minimum fence or wall height and required landscape buffers. Chain link fencing shall be prohibited along any frontage or area where fencing is visible or potentially visible from a public right-of-way. Stored materials and vehicles shall not exceed the height of the required screening. Failure to maintain compliance with the conditions of approval or applicable provisions of the zoning code shall constitute a violation subject to enforcement action and may result in the revocation of the special exception in accordance with city procedures. That concludes my report. I would like to invite Mario
Yes, Mario.
Sotolongo up here, and perhaps we may want to add a recommended staff condition to address compliance issues and satisfy any liens and fines tied to the subject property, but that's up to the board.
Thank you, Mr. Rialli.
Good evening.
Good
Madam
evening.
Chair, members of the board, Mario Sotolongo, City of Pompano Beach Code Compliance Department. My first visit to this property was about a decade ago, and the violations are occurred throughout this time. Granted, they were attributed to one of the previous property owners, so we're dealing with a brand new property owner, and I'm hoping, and based on what I saw this morning, there is a huge improvement on the property already. However, we still have a number of outstanding issues that I would like to bring to your attention. Again, dating back to 2015, case 1509000069, that the violations in this case pertained to off-street parking, loading areas, and surfaces where the vehicles were being stored. Back in that era, this was being used as a junk vehicle storage place, and it was more of a transfer station. So vehicles would come in and then they would ship them out. So it was vehicles were there for a temporary period of time. However, they were unloaded from car carriers, and one of the issues that brought our attention to this site was that these carriers were lined up on Andrews Avenue for close to a mile downstream, and they caused quite a commotion with traffic. So again, that's what brought us to the site, and that's how we started working with the previous owners. Case 1509000070 dealt with landscaping and the use of the property, which was not permitted at the time. That case is currently closed because now the site is vacant, so that issue is no longer there. Moving forward, a year or two, the operators here during rainy season started discharging water from the site onto the city right away. And for a period of time, we made a big effort through 3 code cases that we brought to special magistrate to put a stop to that practice. And in all three cases, magistrate imposed a fine of $1,000 as a penalty. Those cases are closed technically because it was a one-time issue. However, the fines still remain. There is also a case that was initiated by the building department. That's case 1606002922. And this is for remodeling of the offices. There's a rather small, in comparison to the site, it's a small building that's right on the corner. And offices, bathrooms, all that was remodeled without the benefit of permits. That case is still open. We don't have any information as to any efforts being made to make those corrections, and we hope that this new owner will address that. At this time, we're pleased with what we see so far. So I'm hoping that this will be what the future holds for the site. However, we do need these items to be addressed by the new owner, particularly the fines. There's a substantial amount of fines that have accrued in these cases, and we would absolutely entertain a reduction of those fines, provided that, again, compliance is achieved. But that will be at a later date. You know, the property has to be in full compliance before we can entertain any reduction of those fines.
So, Mario, basically, if in the event that this board should approve this petition, we need to put something into the petition that these code violations and the building department's violation is taken care of. Is that correct?
Yes, please.
Okay, thank you.
Any additional questions?
Yes, it appears they acquired the property in, I'm gonna say 2025.
Correct.
Have any new violations been documented since?
No.
Has there been any effort, I assume they were notified when they purchased the property of the existing violations?
So what I have seen, and I inspected the property this morning, if I can try to explain, when we initially visited the site, this was a very disorganized operation. You had vehicles parked on dirt and mud and things like that. At some point, there was some effort made to bring some order, and some work started, particularly landscaping, water retention areas, things of that nature. However, that didn't get finished. What I saw today is a fully paved and light poles. I did a little bit of research in the permit system, so I did see that permits have been applied for. However, what's in the system today doesn't address all the issues that we initially cited for.
When you say permits were applied for, did they get permits to pave it? And
Yes.
proper drainage?
Yes, there is a permit in the system for that. I did not find in the system permits for what I could describe as lighting, for general lighting for the site. There is also a brand new chain link fence, and it caught my attention that, as Scott mentioned it earlier, there is a brand new fence around the entire site. So I have not found any permits for that.
So basically, it appears that there's still work going on at the site without permits?
It's very possible. I mean, I know that when we started down this road, this site was enclosed by a wood fence, a board-on-board wood fence. Today, it's a brand new chain link fence. How that came about, I couldn't tell you, but I could not find a permit in the system for that. And again, full disclosure, this property was sold back in August, I believe, of last year, so I cannot attest that the current owner was the one who initiated that work. Right?
So, in the event that this board approves this special exception. Scott, what type of wording would you want one of the board members to put into the motion? Overall, that all permits and fines and everything are taken care of or paid for or whatever? I don't know, but think about it. We haven't gotten there yet. I just wanted to mention it while Mario was here, since he's listed a bunch of them, and it's my understanding that this property had been sold like in between times, and I don't know what lawyer these people went to, but they certainly didn't do a title search. Otherwise, they would have known that there was stuff on the property. Apparently, this owner found out because he was represented. So, thank you, Mario.
You're very welcome. Nothing further, Scott? Council?
All good.
Thank you.
Welcome back.
I was not expecting that at the beginning of this. Hi, Andrew Shine with Bills and Sunberg, representing the property owner. I guess I will start with just a little bit background cleaning this up. My client is a company called JD and iOS, and what they do is they're a national company. They buy up industrial properties that need a lot of love. They clean them up and they rent them out to new tenants. So this property needed a lot of love. My client purchased it, and the closing date was September 25th of last year. They didn't take possession until the next month. So they've had this property in their hands for less than 5 months now. And part of what we've been doing now is just cleaning it up. I don't believe we did the fence. I can double check into that. We did get a paving permit, repaved the entire property. So it looks a lot nicer than it did before. But saying this because that's my client's whole purpose, is to buy rundown industrial properties, clean them up, and lease them back out. And part of that is the special exception application. So shortly after closing on the property in September of last year, they applied for a site plan in order to redo the whole property. So repave, new buildings, new landscaping. They applied very, very shortly after. We did do a title search. They were very aware of the existing fines. And we had discussed with staff that once we go through this, we'll work in good faith. Can the city also work with us in good faith to close out the fines at the end of the process? This tonight is part of that process. When we were at DRC yesterday for the site plan, it's part of that process. So we're working diligently. I know there's a long history and it's an ugly property, but please don't let that cloud your judgment tonight, because that's not my client, and we're here really for the purpose of fixing that up. So to start, the property is located at 951 Southwest 12th Avenue, which is also Andrews Avenue here. And it's located, I did not know this was the area, but then the property appraiser calls this area the Andrews Industrial District. So all the way from McNabb, all the way up to Atlantic on Southwest 12th Avenue here are industrial uses. You have warehouses, you have heavy distribution uses, really heavy truck uses, noxious type of uses. But that's what industrial districts are for. It's to put these all in one area. To the northwest, we have the Harris Casino. And to the east, across 95, you have John Knox Village and some residents there, but that's all the way across 95. This is an older aerial of the property. It's the most recent one published, but it's from last year. The property needed help. There was outdoor storage everywhere. It was not well organized. It was dirty, dusty, needed paving. Landscaping was dying. This is the condition that they purchased the property in. And this is the new proposed site plan. So there will be 3 main buildings scattered throughout with outdoor storage around the property. To our west, we have a large warehouse, not expecting any issues with that neighbor. To the north, more industrial uses, south, more industrial, east, more industrial. That said, we are still required to do things like buffer yards and screening. So we're keeping some of the trees that are existing, the ones that are good and can survive, and then doing new landscaping around the entire perimeter of the property. On the north is not a street, it's an access road. It only serves our property and our neighbor to the west. We are improving that as well. And then repaving, restriping, just making the property look a lot nicer. We are also platting this property. This property requires platting. So we're in the county now during that process. They are reviewing that for things like traffic. 12th Avenue here is a county road, a county jurisdiction road. Traffic-wise, our counts currently at the county are around 7 p.m. peak hour trips, so it's not a large traffic generator. We did include the narrative giving the rundown of all the different special exception criteria. I do want to hit on most of the points, and I've grouped some of them together where it makes sense. The first three are that it's consistent with the comprehensive plan, complies with the zoning district standards, and the applicable use standards. We are processing a site plan concurrently. DRC, it's a major site, I think it's a major site plan, but regardless, DRC is reviewing it for the criteria against the code. We're not asking for any variances. We're not asking for any waivers. So it will be consistent with the zoning district standards and the specific use standards. And for the comp plan, this is an industrial use in an industrial area. It's where it makes sense. The next is that it avoids overburdening any capacity. The utilities, water, sewer, that's all reviewed by the utilities department as part of DRC. This is a relatively low generator of things like water and sewer demand. It's not like an office building or restaurant. So we're not expecting any overburdening of facilities, and utilities has actually already signed off on the DRC application. Next is that it's an appropriate use and compatible with the general area, looking at intensity, density, character. Again, this is in the Andrews Industrial District. It's an outdoor storage use in an industrial area. A lot of people don't like industrial properties. You definitely don't like to live next to one, ideally. But industrial properties are needed. Pompano is lucky to be one of the few cities in South Florida that has really kept their industrial areas. And it's become a base to serve other counties and other cities around the area. It's, I assume, good for the Pompano tax base, but it's just good in general to have more industrial uses and to have newer industrial uses rather than the old outdoor storage that was there. So it is generally compatible with the area as an industrial use. The nearest residential is to the west. You can see it looks like a residential area. Their primary access is on Power Line. Ours is on Andrews, so there should be little to no interaction between cars coming to our property and cars going to the nearest residential area. The next three are neighborhood compatibility type items: avoided noise, odor, glare, adequately screen and buffer, and no deterioration of water or air resources. Again, this is in an industrial area. Outdoor storage is not the most noxious use. We're not a concrete manufacturer or a heavy chemical manufacturer. It's not really a noise and odor type of use. But even if it was, we're providing our buffers and we're in an industrial area. So we're not expecting any residential or even normal commercial tenants to even know that this exists unless they drive by it. The next two are that it maintains safe ingress and egress and traffic flow, and that it protects property values around the area in the neighborhood and neighboring lands. There will be, right now we're proposing two entrances, one on that driveway on the north that is not going to be the main entrance, and the second is the driveway on Andrews Avenue or Southwest 12th Avenue. Again, the county is reviewing this since this is a county jurisdiction road. For safe traffic flow, right now we're going back and forth with the county on whether they're going to require a right turn lane in, but it doesn't look like from our traffic counts that the county's going to require that. So I don't, no offense to City of Pompano transportation staff, but the county is a lot stricter when it comes to their roadways than most cities are. So we're comfortable that if the county, if our traffic counts and the county's traffic counts say that we're not going to have traffic issues, then we're not going to have traffic issues. This is what it looks like now, and this is just the new site plan overlaid. So you can see you're still going to have outdoor storage, but in general, the area is going to be cleaned up, wider landscape areas, things like that. I know that this is an important one, number 11, that it fills a public convenience. And I did hint on that earlier, that industrial uses are needed, and outdoor storage areas with an industrial area are needed. These are things like for construction projects, if you were to rent, they're not going to have cranes here, but if you were to rent heavy construction equipment, they need to be stored somewhere, and most of them are not stored inside of a building. So if we want construction to happen, and if we want building materials and supplies, and we want this to be done efficiently and be able to distribute, not have to ship our things in from Orlando, you do need these types of uses in the neighborhood. They're not the prettiest uses, they're not the cleanest uses, but they're needed. And they're needed in places like this. And second to last, that it complies with all city, state, federal laws and regulations. We will, of course, be doing that. And lastly when analyzing the neighborhood impact, you're supposed to look between 500 feet to a half a mile away when analyzing, is it compatible with the neighborhood? This is about a half of a mile radius. As we've discussed before, it's really only industrial uses, a small hint of a residential use a half a mile away, but again, they don't share any roadways and they're not going to know that this use is here. I did want to bring this up, so let's go back to this plan. If you can see in the middle of this plan, there's a building there. This is the plan that was submitted for this application. If the board is inclined to approve this tonight, and this is a shot in the dark from my perspective. I'm not expecting the board to say yes, but it would be great. They do have an interested tenant who may want to not move forward with the building in the middle. This would be between 20 and 30,000 more square feet of outdoor storage area. So where that red circle was in what we had submitted is a building. And what we might want to do in the future is not a building, and it's additional outdoor storage. I do believe this board has the ability to put certain conditions on that don't require us to come back in certain circumstances. We would ask, and again, not expecting it, but we would ask that some condition be put on here that allows us to increase outdoor storage area in the middle of the site without coming back to the board. We would still have to amend the site plan, but not that I don't like speaking in front of this board, but I would prefer not to come back if possible. That was my last slide, but I'd also lastly want to touch on the condition for the code violation. Part of why we're doing this is to clean up the code violations. We plan on redoing the entire site. So once we redo the entire site, all the code violations are gone. So I just don't know how that would work in a condition because it's kind of chicken and egg situation. We need this in order to clean up the code violations. We can't clean up the code violations without redoing the site. So we know it's out there, it's hanging over our heads, it's a lien on the property. If you do make it a condition, I would just ask it to be worded in a way that doesn't get us into that chicken egg situation. Thank you.
Thank you. Does the board have any questions?
Yes.
Yep, Penny?
I just wanted to, just for purposes of clarification, because I did hear Mr. Shine in regards to what your client intends to do. I think in discussing this matter with code enforcement, they mentioned that there's one of the buildings, I think it's the sole building that exists on the site today, has an ongoing code violation. Am I correct, Mario, on that one? A building, I think building violation.
Yeah, the bathrooms and stuff.
Again, Mario Sotolongo, City of Pompano Beach Code Compliance Department. Yes, sir, that is correct. There is a case that is currently open and active, and that is for interior remodel of the one building existing on the site.
And so, Mr. Shine, just to clarify, when you mentioned about your client redoing the site, does that include a demolition of that building and a construction of a new building?
Yes, that is the current plan. Worst case would be another remodel, this time with permits.
But you don't know at this point?
The plan is to keep it. It's shown on I guess it depends on which building it is. Is it the northeast building? Okay, then the plan is to keep it, but fully remodel it.
So to address the concern he had as it relates to the conditions, I think there are two items. One, as far as the code compliance, I think typically the language would include that he must come into compliance with the code applicable to the property and satisfy all outstanding liens. That should be sufficient enough to allow, should the board decide to approve, to allow the applicant to go through the process, whatever that might be in regards to the DRC, ultimately to get to a point where you are going to come into compliance, and then subsequently, go through the issue of satisfying those outstanding liens, even if that includes a reduction, which, again, that's going to be left up to code enforcement and special magistrate. But I think that should be sufficient enough. The second issue that you've raised as it relates to if your client decides to no longer construct the building in the center, I believe goes back to one of the conditions where it talks about if there's any material deviation, that shall require a new special exception application. And maybe there is an exception, if Mr. Reale approves, an exception that can be made unless there's an increase or extension of the outdoor storage within the premises or within the property. That might be an exception to that material deviation.
Yes, we could, that would maybe considered a minor deviation. It would obviously still need to be looked at by staff, particularly fire for life safety, access, that sort of thing. But because it's in the middle of the site and because the requirement for outdoor storage as a principal use requires significant perimeter landscaping and buffering, I don't think that's significant and material. I think it could be, I don't think it would require that to come back for a new special exception.
I will withdraw my request then. Thank you. I do have a question on the code lien. Would that be a condition? It can't be a condition of building permit because that creates the chicken and egg situation. We need the permits in order to clean it up. Would it be a condition of CO, certificate of use, zoning compliance permit?
Again, we kind of talked through that issue as well. I'm always of the belief that there should be deadlines and timelines. But in speaking with our code enforcement department, they have indicated, Mario, I don't want to speak for you, but it did indicate that it would not be tied to either of those benchmarks and that liens would be the liens.
That is correct. Our ultimate goal is compliance. So basically, we want to achieve compliance. The fines and the liens are means to an end. So we don't want to tie your progress to that relief process. However, our internal process requires for compliance to be achieved first. And then once that's done, then we go back to the relief process.
Of course. Yeah, I think we're on the same page. Compliance is our goal as well.
Is there anyone else in the audience that wishes to speak in favor of this petition? Is there anyone in the audience that wants to speak against this petition? Seeing none, public hearing closed.
I've got a question.
Wait, do the board members have any questions? Penny?
First of all, just out of sheer curiosity, what are they looking to store?
Right now, a lot of their tenants are heavy equipment tenants, so like the Caterpillar, Bobcat brands. That's usually their bread and butter.
Okay, I heard someone mention that there was a permit for the paving that was done.
Yes.
What about the civil stormwater?
That's part of this. We need approval from
So they paved,
PRC.
but they didn't put in any appropriate.
I think the paving was really just more of a temporary fix. When we come back, some of these areas are going to not be paved. We're going to need to cut into them for landscaping. That was really a temporary fix.
Okay.
The whole site's being redone once the site plan is approved.
Did your client do the paving?
Yes, they did the paving.
Okay, so they put in paving without drainage, which is, so I assume the paving was not permitted.
No, the paving was permitted. I can't speak to the drainage part of it, but the paving was permitted though, correct? Yes, I can't, it's not a yes or no, I just don't know the answer to that.
Okay,
But
well,
the
I mean,
paving,
I see Keith is on the team, so I assume Keith is doing the civil engineering. It just strikes me as quite unusual that you'd be able to get a permit for paving with no appropriate drainage.
unless it was included. Again, I can't speak to
Yeah, no,
that.
I.
It would surprise me that the
there's
city
no
would,
permits for, there's no environmental permits for for a stormwater system on the site.
Understood. Yeah. If the site plan is approved, this is all going through city's engineering department again. This is all being redone. But everything my client did, they did with permits.
Anyone else on the board have a question?
Yeah, you mentioned that you might have a client that might, or a tenant that might take this over. What do they want to do to it?
So no matter what, a tenant is taking it over. My client, all they do, they just own properties. They don't operate. They buy bad industrial properties, clean it up, and then lease it out to tenants. And their ideal tenants are heavy equipment rental. Some of them are building supply or either sale or rental, so like scaffolding, maybe lumber, but most of the time their sites have heavy equipment rental tenants. So it would be that, Bobcat, Caterpillar type brands.
And how do we know if it's not going to be like Mario said, that there'll be 30 trucks lining up to get in there to put their storage or to grab their Bobcat? How do we know all that?
Well, we're not allowed to do that. Those are against the code. It's kind of a trick question at the end of the day because I can't guarantee that a future tenant won't do something. We don't have full control of them. What I can say is that the site will be designed to limit those possibilities. So when I was talking about going through the county for a turn lane, things like providing turn lanes, they take vehicles off of the main street and put it into a turn lane. And that's all governed by numbers. It's just traffic counts. So that's it. I will say these outdoor storage industrial uses are not heavy traffic generators. People come, and if you rent a backhoe, you're coming there one day and keeping it for 2 weeks and then coming back. It's not like a retail or restaurant use. So. And it's also in an industrial area.
Okay, and just, I'm pretty sure, curiosity, if this all goes through and everything, you'll have the permits to get the draining, all the paving done, and then everything up to standard that needs to be. There's enough facility for, that was the other thing, so is it gonna be guarded? Will restrooms be open? What I'm trying to say is if someone comes late at night and you have to use the restroom, they might use the restroom somewhere, and I'm just wondering if you're going to have all that. Is that all going to be in plans? I don't think that has to do with this, but I'm just saying.
No, that's all right.
All the plans need to be up to standard, of course, with that kind of stuff. So I guess they'll worry about that.
Yeah, no, I don't mind addressing a little bit of it. It'll be gated. It's only open during business hours, so can't prevent trespassers, but it's going to be gated, closed off during business hours. It's not like a public establishment. If someone's coming to rent a backhoe, yeah, they can use the bathroom in the office, but it's not an open to the public kind of place.
So it's open when someone's there when it's open.
Yeah, business hours. Yeah.
Perfect.
Any other board member have a question?
I do.
Yes, Raphael.
And it's essentially the same question I had to the prior applicant, which is regarding standard number 11, which talks about a demonstrated need for the public convenience and service to the population of the neighborhood. As I recall, there's already some heavy equipment storage in that area.
There are a lot of industrial uses around that area, absolutely. And in that criteria is a very important word, and it says neighborhood. So when you think of neighborhood, again, that's in the code defined within 500 feet to a half a mile away. This is not going to benefit somebody on the beach. This is not going to benefit everybody in Pompano. But it does benefit the city of Pompano as a whole. We have an ugly, ugly industrial site that's being cleaned up and made nicer. That's one huge benefit for the neighborhood. But two, we wouldn't be buying this property and converting it into outdoor storage if there was no demand for it. This is not this is a very sophisticated company with sophisticated investors, and they only buy where there's demand for the use. So I believe there's a truck storage place just 2 streets north. This wouldn't be like a truck terminal storage, but overall, 2 huge community benefits and neighborhood benefits. We're cleaning up an ugly site, and we're providing a use that there's always demand for.
Okay. Any other discussion from the board? Can I entertain a motion, please?
2517, 26, my apologies. No, I'm sorry. 2617 000002. I move that we find there's competent and substantial evidence in the record that all the requirements for granting the special exception has been met, and that we grant the special exception subject to 5, but
Plus.
we have to add
Plus.
plus
The code and.
plus all the code
liens.
violations and buildings up to standard.
It would be compliance with the outstanding code violations as well as satisfaction of all outstanding liens.
Like what he said, yeah.
Correct. Conditions requested by staff.
Do I have a second?
Second.
Any further discussion from the board? Meredith, would you please call the roll?
Joe Circuzzi,
Yes.
Penny Cutt,
Yes.
Nicole Henniger, Raphael Katz,
No.
Linda Thomas,
Yes.
Charlotte Burry.
Yes.
Thank you all.
Happy cleaning.
Thank you. It's going to take us a little bit of time, Mario, but we're going to get there.
We are now on item number 3, is a variance from Sabia Beach Condominium Association, Planning and Zoning, case number 26-11000001. And Mr. Thomas Johnson, good evening.
Good evening. Good evening, board members. Good evening, Chair. This
Didn't have to.
commemorates my 57th consecutive year appearing before this board. I know I look a lot younger, but I'm not. I'm Johnston, Johnston, 633 East Atlantic Boulevard here in the beautiful city of Pompano Beach. And unlike other lawyers who appear, and they're all good, whatever I advocate, I live in this city, so it affects me directly or indirectly. And I thank you for hearing us tonight, and I thank you for your service. I've served on city boards over the years and had agendas and worked with different members of the public, and I always commend the board members. Thank you.
Thank you, Tom. Mr. Reale.
Thank you, Madam Chair. Again, Scott Reale with Development Services. In this case, the applicant landowner requests a variance from Section 155-5102D1 of the Pompano Beach Zoning Code to reduce the minimum required number of off-street parking spaces to 107. The request is based on the removal of 32 parking lifts in lieu of providing 117 off-street parking spaces as previously approved under Administrative Adjustment 15-16000026. The subject property is located on the east side of the 700 block of North Ocean Boulevard, which of course is A1A, on the Barrier Island. Sabia Beach is a multifamily high-rise condominium that was approved by the Planning and Zoning Board on April 22nd, 2015, under Planning and Zoning number 14-12000052, and constructed via building permit 15-4681. The approved site plan included 71 dwelling units with a required 129 parking spaces. Ultimately, 69 dwelling units were constructed. The project was the first development in Pompano Beach to utilize parking lifts, allowing 2 vehicles to be parked within 1 standard size parking space. Following site plan approval, minor administrative adjustment PZ 15-16-000026 was approved, granting a 10% reduction in the required parking, resulting in a reduced minimum requirement of 117 parking spaces. Although the development exceeded the minimum parking requirement at that time, the developer proactively sought the reduction in anticipation of potential future removal of parking lifts to better accommodate larger vehicles. This was back in 2014, 2015. The development currently provides a total of 139 parking spaces, which exceeds the previously approved 117 parking spaces. However, the applicant proposes to remove 32 parking lifts As a result, the affected spaces would each accommodate one vehicle instead of two, reducing the total number of available parking spaces to 107, which represents a deficit of 10 parking spaces relative to the approved administrative adjustment. The applicant asserts that the requested reduction is warranted due to structural concerns associated with parking lifts, which have experienced corrosion from prolonged exposure to sea air. The applicant further states that the parking demand has never reached full capacity, even during peak season, and that for approximately 9 months of the year, a significant number of parking spaces remain vacant. As an aside, we did send our city's parking manager to the Sabia Beach development today to look at this. He did provide an email to me earlier today. Didn't get time to get in the staff report. I can read that later on if you would like. But for right now, there are 8 variance review standards. The applicant has addressed each of these in detail, and should the board determine that the applicant has provided competent, substantial evidence to satisfy the 8 variance review standards, staff recommends the board include the following conditions as part of the order. 1, the applicant shall obtain all required governmental permits and approvals, including building and zoning compliance permits. 2, the property shall maintain a minimum of 107 off-street parking spaces. The variance approval is based on the removal of existing parking lifts due to documented structural and maintenance concerns and shall not be construed precedent for additional parking reductions on site. 3, this variance shall not be interpreted to allow an increase in the number of dwelling units, bedrooms, or intensity of use without additional parking being provided in compliance with the zoning code or further relief being granted. And the 4th recommended staff condition, all remaining parking spaces shall comply with the minimum dimensional and accessibility requirements of the zoning code. And that concludes my staff report for now.
Thank you, Mr. Riley. Mr. Johnston.
Yes, thank you so much. We totally concur with staff's report, and in fact, Mr. Reale was very generous with his time, because I first had a meeting prior to filing this application, which is required by the code, and we came up with 14 parking spaces for the variance. Later, we discovered that there were 4 spaces on the ground floor by the porte-cochere, 2 on the left and 2 on the right. So this request, although the client is removing 32, wants to remove 32 of these wretched lifts, and I'll get into more on that and why they're wretched. They weren't when they started. We're only asking for relief from just 10 spaces this evening. Good evening again. This variance concerns Saba Beach Condominium at 730 North Ocean Boulevard, completed in 2019. The project was started by the developer in 2016 and produced a very fine, quality, and beautiful building. It has exclusive valet parking for everyone, every day, 24 hours a day, okay? With the exception of several owners who have selected parking spaces on the 2nd floor. This does not concern the 2nd floor. There's a small space on the 2nd. This concerns the 3rd floor where these automatic lifts are. The majority of the residents have parking on the 3rd floor, and that is all valet parking. At the time of the development of the property, the developer elected to purchase from a German manufacturer automated parking lifts which allow one car to be mechanically elevated on top of another. Presently, this parking system has failed, as nobody anticipated the corrosive nature of the sea air from the Atlantic Ocean, which has caused a multitude of problems with the hydraulic lift mechanisms in steel structures. And in fact, the steel structure that the car actually drives on, they're rotting out. So you can't even lift one with the chance of them falling through. Presently, there are 32 lifts that have the base floors corroded to a point that they're not safe to lift automobiles any longer. This premature deterioration and corrosion by salt air have rendered these lifts unsafe and unusable. There are 32 parking spaces on which the lifts are fashioned, which provide 32 parking spaces on the lifts and 32 parking spaces below when they're raised. Applicant is seeking to remove all 32 lifts because of the unavailability of parts, major deterioration of the steel structures, hydraulic lift mechanisms, and the electric solenoids rendered ineffectual and unsafe. Why this developer? I didn't get an answer to this question, but it came to my mind. Why this developer chose not to use a U.S. manufacturer, but to buy these from Germany, I don't know. But my clients had nothing to do with the building of the building, the selection of these lifts. My clients are the wonderful 69 families that occupy this facility, and they had nothing to do with these lifts at all. They just inherited this problem. Out of abundance of caution, the condominium board of directors have inherited this design flaw choice of the original developer, and not through a problem created by the board and the current owners, are left with the problem of spending millions of dollars to replace these lifts. This property is unique, as it is the only one building that I'm aware of that has these lifts, and it has all valet parking. Even in peak winter season, the handicap parking coupled with guest parking and residential parking spaces have never, ever, since 2019, filled to capacity. There have always been surplus parking spaces. The board has done a thorough analysis and consulted experts, and everyone has concluded that they're no longer safe, feasible to maintain these lifts from a safety standpoint, and they need to be removed. By removing the 32 lifts, there would still be 32 parking spaces available underneath the lifts. This variance request for reduction of 32 lifts and property had been received an earlier administrative adjustment according to the site plan, and you heard Mr. Reale comment on that in 2015. Presently, if the 32 lifts are removed, the net parking deficit according to the code, an interpretation given by the Development Service Department, would show the property would require a variance of 10 parking spaces. And that's all we're seeking is 10 tonight. It's the smallest possible variance. In my career, it's one of the smallest possible requests that we've had, and we know that's one of the criteria. Again, these 10 parking spaces are not fundamental to the safe, convenient, and successful operation of this beautiful condominium, as their removal would not be a detriment to the building, nor would it cause any additional parking to be placed on the street, or importantly, burden any of the surrounding neighbors' properties. Without these 10 spaces, the building can well sustain all of the parking during peak and off-season months. 75% of the year, 9 months, most of the residents are not in occupancy. For 3/4 of the year, most of the parking spaces are totally vacant. The board of directors has elected to request this variance of 10 spaces and feels the removal of these lifts is based upon safety at the recommendation of their experts and based upon the lifts that can no longer support automobiles. And I'm going to ask when I finish here, Mr. Reale, to read the letter, because the city contacted us yesterday, and I have the manager of the building here today who's going to come and testify, Mr. Scott Bragg. But the city asked for their parking manager to come out and inspect, and they met Mr. Bragg this afternoon, and they walked through the entire area, and the report, I believe, will show, I haven't seen it, I've just heard about it, will show that the city's parking manager inspected this area and concurred with the board. During the development of this property, and it is suggested that the developer did not realize the corrosive effects of the salt air. Of course, all he would have had to do is talk to the chair lady or talk to myself, who've lived here all our lives, and we could have told him how impractical this was, but nobody asked us, okay? The effects of salt air would have the detrimental effect on these parking lifts, and therefore inadvertently burden the succeeding owners, my clients, the present owners, and the board of directors with this issue. The current board of directors have given this request every possible consideration, and before the filing of this variance have had council work with the Development Service Department to provide this request to be the minimum number of spaces effective for relief. Now I enclosed, and you should have in your backup, the site plan, and I refer to it. You should also have several color photos of the lift. Hopefully you received those in your package. To satisfy the requirements of this various application, applicant would show substantial evidence in the record to meet all 8 standards. Looking at the requisites, there are extraordinary and exceptional conditions such as topographical conditions, that's in parens, narrowness, shallowness, shape of sides pertaining to this land or structure. And we're talking about a structure, we're not talking about the land, We're talking about the structure of the building, the structure of the parking provided, and the way the parking is provided, for which variance is sought that do not generally apply to other lands or structures. This building is unique. The lifts sought to be removed are unique in their nature, having been manufactured and designed in Germany, imported and installed on the third floor of the parking garage. There are no other applicable issues as to any other neighbors. No one could benefit this, and if you grant the variance, it's not going to set a precedent for any other buildings because nobody has this kind of a parking arrangement. Number B, extraordinary and acceptable conditions referred to in A above are not the result of the owner, and I think I've killed that fly with a sledgehammer. My clients bought these units, they were happy with the units, and then the salt air set in, and now they've got this problem that landed in their lap, so it's not their fault. C, because the extraordinary exceptional conditions referred to in paragraph A above, and the application of this code to the land and this or structure, and this is structure, not land, for which the variance is sought would effectively prohibit or unreasonably restrict the utilization. The client, I think Mr. Reale will agree with me, has a right to remove 22 without the variance. But why take only 22 unsafe out? Why not take all 32 off? That's why we're here to give those last 10. It's kind of a housekeeping thing with no impact on anybody, no adverse impact on the city, not on the neighbors, only to benefit really the people who own this property, the unit owners. They're our precious neighbors, okay? By not being able to remove the 32 list possess unnecessary and undue hardship on this applicant if the variance is not granted. The hardship is demonstrated in the paragraphs above. The variance would not confer any special privilege on the landowner that is denied to other lands or structures that are similarly situated. This is such a rare individual case because with the exception of this building, there's probably only 2 other structures, and I've checked on 2 other structures and I can't even find them, okay, but I just said 2 in my application. These designs, well, I only know of 1, and that's my client's property. Those designs and construction of the lift are not the same as were placed in the building during construction of this developer, and therefore completely unique circumstances that would not confer, this is important, any special privilege by granting this variance on the landowner. It would not be available to other landowners. If other landowners had these issues, then you could entertain that, but this is not going to set a precedent. By removing the 32 lifts, there would still remain 32 parking spaces, and according to the calculations, the variance request is reduced to the 10 parking spaces. This is necessary minimum. Applicant is not asking for 32, 10 space reduction only. Number F, the variance is in harmony with the general purpose and intent of the code. This is a safety issue. If we're not a safety issue, I would not be here tonight. The granting of the variance would do nothing to undermine or erode the spirit of the zoning code, and the zoning code provides this variance as a relief valve under unusual circumstances such as the ones these owners are facing, and therefore will within the harmony and spirit of the zoning code. And it's well within the code. The code provides this as a relief valve. Variance would not adversely affect the health or safety. In fact, this is a safety issue. Sole purpose of the removal of the list is to increase safety to the residents and to the owners and to the valet car parkers. The current lifts are unsafe, and therefore this request squarely meets the purpose of maintaining the health and safety of persons residing in the building, and that certainly takes care of this particular requirement and element. A variance for these 10 spaces would have no effect upon the neighborhood, nor would affect the property values or improvements in the neighborhood. And since it will not create any kind of burden or overflow in the parking spaces, this property also contains sufficient surplus spaces. Even if the 10 are gone, we still have a surplus. And number H, the variance is consistent with the comprehensive plan. Comprehensive plan provides for parking. And so we would appreciate, we had 2 meetings with staff, one on November 19th, one on December 11th. And we appreciate your consideration of the application. I would ask, before I ask Mr. Bragg to come up, Mr. Raleigh, could you share with us the parking gentleman from the city, our parking manager who came out and inspected this property? Could you share that?
Yes.
Yes, go ahead.
This was from Jeff, an email from Jeff Lance this afternoon, who's the city's parking manager, to myself and to Max Weems, another principal planner in development services. Good afternoon, gents. I met with Scott, meaning Scott Bragg, not myself. Scott Bragg is the general manager of Sabia Beach, this afternoon and inspected the ground plates of their lifts. Attached are a few pictures, primarily of the east-facing garage that shows the plates on these lifts, which are severely corroded and in many cases have areas that have collapsed from where vehicles have been parked. I am certain this corrosion is due to the corrosive salt environment, as the garage is not completely enclosed. The lifts are unstable to use for raising a vehicle, and Scott mentioned they have ordered 8 new ground plates to maintain 8 serviceable lifts. Scott also mentioned that in his time, they have never had the need to raise a vehicle, as this location is very seasonal. He mentioned this is a very busy time for them, and I noticed many lifts were unoccupied. I could go on, but that's the gist of it. If I could read the whole thing, but that's.
Well, Madam Chair, I'll stop for a minute and I'll ask Mr. Bragg, the manager of the condominium, to come up.
Yes, please.
He has some comments I think that are salient for you to consider. Please state your name and your address, sir.
State your name, spell your last name, and state your address.
Good evening, everyone. I'm Scott Bragg, B-R-A-G-G. I'm representing Sabia Beach at 730 North Ocean Boulevard, Pompano Beach. My address is 1057 South Ocean Boulevard in Boca Raton.
Mr. Bragg, have you been sworn in?
Yes, I did before. Yeah.
You did? Thank you.
Absolutely. So I'm here, I'm the buildings manager at Sabia Beach Condominium. I work for First Service Residential, which is a big management company, one of the biggest ones in South Florida. We also have a valet company that works 24 hours a day, 7 days a week, 365 days a year. It's Global Parking Valet Service, one of the largest valet parking companies in South Florida. They just a great operator and a great vendor that we have on board with us. They are fully insured, and they additionally insure our property. We have garage keepers insurance as well. As Tom had mentioned, we have 2 stories for parking. A second story, which is half valet, and a handful of resident owners that own some spots that the developer had worked out deals with. The third story is valet only. So only the valet parkers go up there. These 32 lifts are totally deteriorated. They're unsafe, and they also are destructive to the unit owners' cars. And our unit owners are pretty well-to-do. They've had Bentleys and Ferraris and all types of very nice cars. When we have to park up onto these lifts, some of the valets actually will hit the doors. They hit these expensive rims. Everything is rusted out. It's very unsafe. They're walking on rusted platforms. A couple of valets have caught their feet and their heels on some of these lifts and have been hurt. I've been there now for almost 3 years this June, and we have never had a time where we've ever had to use a lift, knock on wood. We don't use the lifts at all. They just sit there and rot in the garage. If there was ever a time where we moved into the future, this valet parking only 3rd floor garage, if we had to stack a couple of cars here and there, the valets couldn't park. I don't know if you've ever been in New York City or a big city where you have to stack cars. If it ever came to that, this valet-only floor garage could be used to stack a couple of cars. But again, this is our busiest week. When Jeff Lance came today with his assistant, Maribel Rodriguez, they walked the whole property. They walked the garage with me. And they saw, this is President's Week. This is our busiest week, this and Christmas week. And there were several open spots on these parking lifts. Plenty of spots. And if this is the busiest week of the year and there was plenty of spots, it was a good indicator over the last 6 years that the board and management has been monitoring this garage, and we do not have a need for these parking lifts. They just deteriorate, and we'd really appreciate it if we can get rid of them. Any questions? Comments?
Does the board have any questions?
I do.
Yes, Raphael?
You mentioned that there was an inspection done today by the city. What time?
He came today, I want to say around between 3 o'clock, maybe?
1 second. Madam Chair, to the board.
Yes.
one of the things that did not have a chance to speak to Development Services about, nor to Mr. Johnson, because I did hear one of them mention that Mr. Jeff Lance was going to be going out to the property. Mr. Jeff Lance's position is a parking manager for the city, principally making sure our parking facilities are operational, as well as parking at various locations throughout the city. He is not an inspector. He's not an expert in that area, so I caution the board on the credence that you give the statement or the letter, because he is not operating as an inspector of those items. Any pictures that were provided, any of those things would speak for themselves, but the board, again, this is not expert testimony, nor is the city involved in inspecting this particular location. I just want to make sure that's clear.
Yes, thank you. Thank you for clarifying that. He is not a safety inspector, but he and his assistant did come out. They met with Mr. Bragg today. They walked over the third floor, and you heard his comments read by Scott. So thank you, James. Appreciate it.
And the board can give it whatever weight you determine it to be, but I just want to make sure it's clear on the record that the city is not inspecting this or giving any sort of imprimatur on the activities there. Thank you.
And that's kind of where I was going, but I'd like to get it in the record anyways. What time of the day was it today on a Thursday?
Around 3 o'clock, I want to say.
All right, so it's a weekday.
Yes.
3 o'clock. Another question. We're talking about a surplus of spots, but you guys already had a 10% reduction granted in December of 2015, correct?
Yeah, let me clarify that. It wasn't my clients that had that. It was the original developer.
Right. But
And before he opened the building.
The building had a reduction in 2015.
Right, before he opened the building for sales, he asked for the reduction. We didn't.
I understand, but the building had a reduction of 10%. If you say you can remove 22 of these without having any issue, correct?
Would you clarify that, Mr. Raley?
Yes, by right, if 22 of the lifts were removed,
Who could be?
could be removed by right, there would not be a deficit. There would still,
And how many lists would you still have left if you remove 22 of them?
We'd have the 10 that we're asking for tonight. We feel that we should get, because they're all dangerous, we should get rid of all of them.
If you have a surplus of spots, why do you need to remove these other 10?
I'm sorry, I didn't hear that, sir.
If you have a surplus of spots already, why do you need to remove these extra 10?
Because they're, well,
I can speak
they're
to that.
dangerous.
They're dangerous, they're dilapidated, there's rust all over the garage, they're not necessary to be there.
What's the cost of replacing the 10 with something else?
I think they're between maybe $35,000 and $40,000 each to put in a whole new lift from Klaus Systems. I think the original ones were 30, but with tariffs and everything else, it's
really
probably
don't
up.
know.
I don't, it could be higher, but I would say definitely north of $30,000 for a lift.
And remember, my clients are the 69 families that live in the building that don't want to have to foot that bill if they can keep from it.
Well, they have Bentleys.
Yeah, I realize there's an economic impact on every variance, but we're not doing it because of the economics. We're doing it because of the safety.
All right. 69 families, assume at least one car per family, maybe 1.2. Fair assumption?
Fair.
How many spots do you guys have?
We have right now 131.
All right,
There's 45 three-bedrooms.
thank you.
And there's how many two-bedrooms?
I don't know off the top of my head.
Just talking about 45 of the three-bedrooms, you have to guess there's at least 2 cars per unit. That's 90 spots.
No, not necessarily at all. No, a lot of our units are extremely seasonal. They'll have one car here in South Florida, and there are other cars at their other residences. Many of our residents only have one car. They come down from Canada, They're extremely seasonal. They'll come down for a few months, a couple weekends. We have a handful of year-round families. When the city originally planned this, or the county or the state, on paper, you would think we need that many spots. But the reality is, after 6 years, it's just not in a time that we've ever had every spot full, ever on the premises.
How many two-bedrooms?
I don't know off the top of my head.
1 and 2 bedrooms. It was approved with 26 units. Again, this was approved 71 dwelling units. 26 units are 1 or 2 bedrooms. That has a 1.5 space per unit requirement, so 39 were required. 45 units were 3 bedrooms or more. That's a 2 space per unit requirement, meaning 90. So at the time, before the reduction, 129 spaces were required. Again, only 69 units were ultimately built, not 71. And then with the adjustment, brought it down to 117 spaces were required.
So 117 was required.
117 is currently required. They're basically asking for 107 spaces right now. So a 10%, a 10 space reduction.
And of that 117,
May I?
22,
Oh, I'm sorry, I thought you were done.
You're good.
I'm sorry.
Just please
Okay,
continue.
of that 117 spaces, 22 can be removed by code. Is that what I understood?
22 of the lifts can be removed by code. You'd still, yes, and then of those, you'd be left with one space each rather than the 2, because that's how the lifts were designed. But and then yes.
Okay.
Are you finished?
Yes.
Okay, go ahead, Raphael.
Currently, it's an all-valet building. Is it always required to be valet by some sort of resolution, or is that just the way it is?
The third floor is valet only. The second floor is mostly valet, but there's a handful of unit owners that own spots, and they can self-park. They generally don't, but there are some unit owners that will go into the second story and self-park their cars.
Okay. This is where I'm hung up, and maybe you guys can shed some light on it for me. The third factor of the following factors do not constitute sufficient grounds for approval of variance. Number 3, the fact that land or a structure may be utilized more profitably or be more marketable with a variance. In my mind, this is just a cost issue. You guys can replace these, you're just choosing not to because you don't want to spend the money.
It has nothing to do with the money. It has to do with the idea that it would be putting money to no use.
It's money.
Because the new one would just rust away.
And we're just pulling up onto an old lift. It doesn't make sense.
Number 3, I think, is because of the extraordinary exceptional conditions.
I was speaking down to the bottom, 1, 2, 3 on the bottom. But if you want to talk about the top one, I had that one circled also.
Okay.
Uh,
Yeah, if you grant this variance, it's not going to apply to anybody else because it's just allowing us to remove those mechanical devices, and nobody else has got them, and nobody else is likely to have them. And
If they're
I think
smart, they won't.
That's not the part I'm asking about. I'm asking about if you have the variance review standards, you have
Yes.
8 listed, and then you have 1, 2, 3, 4 listed below that. I'm talking about number 3 at the bottom, which is the fact that a land or a structure may be utilized more profitably or be more marketable with a variance.
Is that on there?
That's not in the staff report. It is in the code. We have 8 variance review standards, and then it has an additional section, what is not grounds for granting a variance, and that's what,
They're not doing it solely for the economics plays a part of every variance, but they're not doing it for that. Their motivation is they have public liability for people getting hurt. These devices are dangerous. I think we've demonstrated that. They need to be removed. You could remove 22 and not have the variance, or you could remove all 32 of the dangerous devices and get rid of them. By removing a dangerous device, then you allow someone to park.
Talk into the microphone, Tom, please.
Then you allow somebody to park on that space with the devices being taken away. Right now, no one wants to park on top of these devices that are on concrete, but you take them away, then those concrete spaces open up.
I don't think anyone's questioning removing them all. I think the issue is whether there's an obligation to somehow provide 10 additional spaces. My question is reference to the staff analysis number 2, where you talk about the 10% reduction in required parking. Based on the 69 units that were constructed, how many spaces would have been required but for that 10% reduction?
Isn't it 117?
117, right?
No, the 117 was with the reduction. Before,
Another 11?
there were, the site plan, which predated the administrative adjustment, was approved with 71 units. A building permit that was reduced to 69, but at the time, the site plan said there's 71 dwelling units, you're going to need 129 parking spaces. That obviously changed during the building permit stage when there was a reduction of 3 units, 2 units, thank you, and then the corresponding minor administrative adjustment, which was approved because they at the time there were cars were a bit bigger and.
To clarify,
Yes.
they already have a 10% reduction of what is required with 117 spaces.
Yes, the 117 represents a reduction, a 10% reduction.
So they're requesting a reduction beyond 10% so that they don't have to provide additional parking when they already have the 10%. I guess it's a question for council, because they're requesting to change what was already approved, wouldn't we default to the number of spaces that's required based on the 69 dwelling units?
I don't know if it's
Revert, excuse me, revert.
well, the jurisdiction of this board would not go that far, because that's going to be a function of development services as it relates to the required parking. It is my understanding.
Let me rephrase that. If someone were redeveloping a property that had a variance previously approved for the previous development, they would have to come back to get a new variance for the redevelopment. So this 10% reduction applied to them having 117 parking spaces. They want to change what was authorized by the previous administrative adjustment. So does it not revert to the number of spaces that is technically required for 69 dwelling units based on 1.5 spaces per 1 or 2 bedrooms and 2 spaces per 3?
Again, this is going to be development services, but this question has already been addressed, I believe, by development services, in that once the administrative adjustment is given, that is as far as that department is willing to go. There is no further reduction. And Scott, you can correct me if I'm wrong on that, because I don't want to speak for the department.
That's correct, and there is precedent. We've taken variances to the board that have had a previous administrative adjustment, parking reduction, and we've used that as the base. Because it's the same development, it's not an all-new development. So that's been our policy, but we also acknowledge that, well, that's as much as development services can do administratively, and so any additional relief would have to be considered by the board, but we base our reviews and recommendations on that 117 approved spaces, which they're not at, by the way. They have 130-something spaces now.
So how often and what criteria does development services use to apply that 10% reduction?
It's an administrative adjustment. They have their own review standards. Obviously, it's not as like a variance where you have to prove a hardship. But they made a persuasive argument. I believe that is in the backup. I don't know if their justification is, but the administrative adjustment itself is. But I kind of put the summary of the justification in a letter that I wrote to Mr. Johnston back in November, and it said, it was, although the property exceeded the minimum parking requirements, the developer proactively sought a reduction in anticipation of potential future removal of some of the lifts to accommodate larger vehicles.
That was a developer.
Yeah, so I mean, I know I see these lifts in various places in southeast Florida. There are other manufacturers of these lifts. I've obviously never shopped for one of these lifts. It's not necessary to purchase the ones made in Germany and ship them over again. I can certainly speak from a marine perspective that dry storage facilities routinely use similar type structures, both automated and fixed structures for boat barns and such for dry. So there is a lot of newer technology, and you know, that we're talking about vessels that are hauled in and out of salt water day in, day out. Granted, they're rinsed off, hosed off, but you know, some bilge water or whatnot's going to drip on them, and you know, I don't see from my perspective, and we can talk about it after the public hearing closes.
Public hearing is closed.
Okay, so I don't necessarily see how they've addressed the necessary
No, it's not.
criteria.
It's not closed.
Madam Chair, public hearing is still open.
Yeah, I just corrected myself. Thank you. Is there anybody else on the board that has a question?
Question for council.
Yes.
It talks about, in variance result, review standard number 2, about not the result of the actions of the landowner. Does that refer to current landowner, or the developer was the landowner at one point? So is this not the same thing? That I'm just curious.
I think you're playing semantics with the word. It's,
Yeah, the
I'm
intent-
not playing semantics, I'm asking a legit question.
The intent is principally the developer, landowner, the person who created the situation. But because this applicant is the owner, they are given that assignment as well. There's no distinction made between a prior developer and the current landowner.
And I think this is something that can be, you know, identified through due diligence and inspections. You know, if I were buying a unit, I would certainly do my due diligence and inspections.
well, before I ask if anybody else wants to speak, when Sabia was built, I was on the city commission. And prior to its building, I announced to my fellow commissioners that thought these lifts were really, really great. And I told them, I said, you're on the beach, you got the salt. I said, and it's going to be dangerous. And of course, now you've come up with a dangerous situation on the 3rd floor. But you're asking to take away 10 additional ones, which you're allowed to take away 22. It makes sense to me to clear off the whole 3rd floor and not just leave 10. Well, actually, it would be 5, right? It would be 5 lifts.
It would be 10. There's 10 spaces with 10 lifts on them. There's 32 parking spaces with 32 lifts. And if we take 10 off, we can take 10 off without a variance, okay?
You can take 22 off, you said, without a variance.
With 22, right. And so we have 10 spaces, 10 concrete spaces with 10 of these rotting.
Okay, but basically, the 10, I guess I don't understand, but if one car can park on top of another
Yes,
car,
Yes,
okay, it's really the top 10 parking spaces you're getting rid of because you
right.
still have 10 parking spaces
yes,
on the
ma'am.
ground.
We still have 10 under them.
Thank you.
Thank you.
Is there anyone in the audience that wishes to speak to this petition? Is there anyone in the audience, other than you guys? Anyone in the audience would like to speak against this petition? Hearing nothing, the public hearing is closed. Okay, any further discussion from the board or any questions of the petitioner?
Just some further discussion. As I mentioned, you know, I deal with marinas all day long, and there are numerous competing technologies for automated boat storage, automated dry boat storage, as well as traditional dry boat storage that utilize similar types of rack systems. We've got two of them right there in Fort Lauderdale. You know, they're not uncommon. They're becoming more and more common each day. From what I hear, they've already received a 10% reduction. They're asking for a further reduction. All we hear about is how limited parking is on the beach. It just sounds like, you know, these people didn't necessarily do their due diligence. They don't necessarily want, you know, nobody wants to spend money. I hear vague reference to having unused excess parking spaces, but I haven't seen a parking space or specific numbers. However, I don't think that that's even relevant because from my opinion, my perspective, I don't see how they've met the required standards for the requested
Did you want to respond to that,
additional variance.
Mr. Bragg?
No, I understand the boat lifts, they serve a purpose because they need extra space. We don't need that extra space for these lifts, and we have, the building is very financially well off. We've got reserve funding, we just received $4 million from our developer for our 558 hearing. It's not a money issue per se, it's just, it doesn't make sense to put these lifts in, or new lifts, or any type of lift, because it's not necessary. In a boatyard, yes, you need to maximize your space. We don't need to maximize any space. We have enough space as it is.
Madam Chair?
Well, it's pursuant to the code.
No, I understand that.
Requirements, and you already have a 10% reduction. And so, you know, I'm not saying you have to replace them with comparable style lifts and comparable style stacked parking. Maybe there's another option, another opportunity to purchase spaces somewhere else, have the rights to spaces, find space elsewhere on the property. But I'm just saying, you know, the building's already been granted a 10% reduction, and you're looking to make a substantial reduction from what was there, and I'm hearing vague references to, well, we have extra space.
Well,
May I?
You're welcome to come visit us anytime, you know.
If they have the extra space, then they don't need to remove the other 10, or they can make some other use of them, or replace only the 10 that they need to replace and not the other 22. They can do whatever they want, but they have all these extra spaces. There's no hardship that requires our involvement.
Is there any other questions from the board? Any other comments from the petitioner?
Thank you very much for your attention.
Thank you.
Appreciate it.
Thank you all.
Okay, well, if there's no further comments from the board, can I have a motion, please?
I'd like to make a motion. In planning and zoning case 26-11000001, I move that we find there is competent and substantial evidence in the record that all the requirements for granting the variance have been met, and that we grant the variance subject to the 4 conditions requested by staff.
Do I have a second?
Second.
Okay, it's been moved in second. Any further discussion? Meredith, please call the roll.
Penny Cutt,
No.
Linda Thomas,
No.
Nicole Henniger,
Yes.
Raphael Katz, Joe Circusi,
Yes.
Charlotte Burry.
Yes.
Thank you.
Thank you all.
Have a nice evening.
We will now take a 10-minute recess. back to order. Item number 4 is a variance. P&Z number 2611000002.
Good evening.
Good evening.
My name is Brent Jones, Jones, and I'm with Expert Awning, and my address is 3381 Northeast 6th Terrace, Pompano.
Thank you, Mr. Reale.
You're welcome.
Thank you, Madam Chair. I'm Scott Reale, for the record, Development Services. The applicant landowner requests a variance from Section 155-3402C of the Pompano Beach Zoning Code, which establishes the intensity and dimensional standards for the general industrial zoning district. The requested variance would allow for the replacement of an existing awning with a street side yard setback of 0 feet, continuing a legally non-conforming condition of the existing building in lieu of the 10-foot street side yard setback required by code. The subject property is located at the northeast corner of Northeast 5th Avenue and Northeast 25th Street in the Cresthaven area. The subject property was annexed into the city of Pompano Beach in 2000 pursuant to House Bill 1979, while the original 1975 building permit records from Broward County could not be located. The property has consistently been used for auto collision repair, service, and paint operations for several decades. Similar to many properties within the East Coast Industrial Center, the existing building does not conform to current setback requirements and is considered legally non-conforming. The building maintains a 0-foot setback along Northeast 5th Avenue, which is the west side, and along the alley, calling it an alley, it might not be, on the east side of the property. The applicant proposes to replace a 45-foot by 27-foot awning canopy located within the street side yard setback area, maintaining a 0-foot setback. Although prior permits for the awning could not be found, the building itself was approved without a side yard setback, and staff finds it reasonable to conclude that an awning previously existed in this location in association with the long-standing use. The property has no outstanding code violations. Building permit number 25-8445 is currently in plan review for the proposed canopy replacement, which prompted the need for this variance request. Staff finds the extraordinary and exceptional conditions are not the result of the actions taken by the current landowner, as the building and its setback configuration predate the city's current zoning code and the property's annexation into Pompano Beach. The 8 variance review standards are included in the staff report. The applicant has addressed each of these, and should the board determine that the applicant has provided competent, substantial evidence to satisfy those 8 variance review standards, staff recommends the board include the following conditions as part of the order. 1, the applicant shall obtain all required governmental permits and approvals, including building and zoning compliance permits. 2, the awning should be constructed only in the location depicted on the plans submitted with this application and shall not further encroach into any adjacent right-of-way. 3, the awning does not obstruct sight lines, shall not obstruct sight lines, pedestrian circulation, or vehicular access, and shall comply with all applicable fire, life safety, and accessibility requirements. And the 4th recommended staff condition, no vehicle repair, painting, body work, storage, or other operational activities shall be conducted outside of the principal building or beneath the awning canopy. And that concludes staff's report, and I'm available for questions.
Thank you. Please go ahead.
Well, like you said, there's a cutout in the building that used to have a canopy on it, and there is an existing slab that covers that area. So basically, the awning will actually not exceed the dimensions of the wall of the structure or outside of the property line. And that's what we're hoping, to get that replaced so, they can have a clean area for, to present cars when they're done.
You're right on 5th Avenue then, what, 2 blocks past the convenience store?
Yeah, the front of the building is on 5th Avenue.
Okay.
And then to the east of it is basically kind of like a roadway / alley.
Oh, I'm very
wider than
familiar
normal.
with it. I live there. I mean, I don't live in.
I used to play baseball there growing up, so I'm familiar with that alley. That's where we played.
Right, yes. And when it was annexed into the city, the county had different rules, and I mean, it's all, that whole place is all small business and
they're all, like,
industrial
building to
business,
building.
all clustered together in one section. I was just trying to get the geographic thing in my head. Thank
The
you.
awning would basically conform with what the building shape and size is, and that's really all we're asking for, is try to get some type of structure there to fill that area in. That's what our hopes are.
Does anybody and board member have any questions of the petitioner? Does anyone else want to speak for the petitioner? Does anyone want to speak against this petition? Public hearing's closed. Again, any questions from the board? Can I have a motion, please?
I'll make sure I'm getting the right one here. Hold on.
Number 4.
Where is it? It's variance. In P and Z case number 2611000002, I move we find there is competent and substantial evidence in the record that all requirements for granting the variance have been met, and that we grant the variance subject to the 4 conditions requested by staff.
Thank you. Do I have a second?
I second.
It's been moved and seconded. Any further comment from the board? Meredith, would you please call the roll?
Raphael Katz,
Yes.
Nicole Henniger,
Yes.
Penny Cutt,
Yes.
Linda Thomas,
Yes.
Joe Circuzzi,
Yes.
Charlotte Burry.
Yes.
Thank you.
Your variance has been approved.
You guys have a good night. Thank you.
Have a good evening. We are now on item number 5, P and Z 26-11000004. Deborah Ullman? Is that?
I'm not Deborah
You're
Ullman.
not, you didn't look like Deborah to me either, but that's what's on my paper.
It's a long story. Edward Canatelli, C-A-N-N-A.
Very different.
T-E-L-L-I, Canatelli Builders, 2101 Northwest 33rd Street, Suite 2800A, Pompano Beach, Florida,
Okay.
33069.
And you have been sworn in?
We have.
You have, and you're going to speak too?
My name is Kyle Nader, N-A-D-E-R, and my address is 2101 Northwest 33rd Street, Suite 2800A, Pompano Beach, Florida, 33069.
Thank you, Mr. Reale.
Thank you, Madam Chair. The applicant landowner requests a variance from Section 155-4302B2G of the Pompano Beach zoning code in order to allow mini-split air conditioning units to be located in front of a principal structure rather than within an interior side yard or rear yard as required by code. The subject property is located on the north side of East McNabb Road between Southeast 7th Avenue and Southeast 9th Avenue in the Cypress Lake subdivision. The subject property is a 4-unit co-op residential development constructed in the late 1950s. The applicant owns 2 of the 4 units. The property is currently subject to open code compliance cases and part related to the installation of the mini-split air conditioning units without the required permits. Those are code cases 2406007212, 2406007243, and 2409005998. That's an open lien on the common area. The mini-split units were installed on the building facade along East McNabb Road pursuant to Section 155-4302B2G of the zoning code. Accessory uses and structures are prohibited in front of a principal structure unless otherwise permitted. The applicant asserts that extraordinary and exceptional conditions exist due to the orientation of the building and site constraints. Specifically, the structure is oriented toward an adjacent waterway to the north rather than toward McNabb Road, resulting in areas that function as rear yard spaces but are visible from the public right-of-way. The applicant further states that existing concrete sidewalks surrounding the structure limit feasibility and alternative locations for the placement of the mini-split units within an interior side or rear yard. The applicant contends these conditions were not created by the current landowner and predate current ownership, as the building configuration and orientation were established at the time of original construction. The applicant further asserts that strict application of the code would result in unnecessary hardship by requiring removal and relocation of the units which would necessitate demolition and repair of existing concrete sidewalks, additional building penetrations, and reconfiguration of mechanical infrastructure. The applicant maintains that the requested variance represents the minimum relief necessary to allow reasonable use of the property, and that the units are currently screened from public view by existing vegetation. The applicant has indicated a willingness to provide additional landscaping to further mitigate visibility from McNabb Road. Again, there are 8 variance review standards. It was part of their narrative that they addressed each of these, and should the board determine that the applicant has provided competent and substantial evidence to satisfy those review standards, staff recommends the board include the following conditions as part of the order. 1, the applicant shall obtain all required building, mechanical, and zoning compliance permits for the mini-split air conditioning units within 90 days of variance approval. Final inspections shall be completed and approved prior to closure of associated code compliance cases. 2, the variance approval shall apply only to the specific mini-split AC units, quantities, and locations depicted on the variance application materials. Any relocation or addition of mechanical equipment shall require separate review and approval. And the 3rd recommended staff condition, the mini-split units shall be screened from view from East McNabb Road through existing and/or supplemental landscaping, fencing, or architectural screening. All screening plans are subject to review by the Planning and Zoning Board and Urban Forestry Divisions prior to permit issuance. Screening must be permanently maintained and in good condition, with any dead or damaged landscaping replaced within 30 days. And that concludes staff's report, and of course, I'm available for questions.
You sure you're ready?
I
Our
just
chief
had to turn my
financial
microphone on.
officer's former significant other committed suicide in this property
Okay.
with multiple violations, and no good deed goes unpunished, and we were asked to be able to clear up the violations. So that's what we're trying to do, pretty much.
Well, that's very good.
Yeah, so I believe everything's in for permit, and the only thing that's waiting, correct, is everything in for permit?
Zoning.
Yeah, it's the only thing that's waiting, but we've submitted all the permits and
Okay.
trying to get them closed out.
And Mario's sitting behind you to go ahead and state that that's correct, right, Mario?
Mario Sotolongo, City of Pompano Beach Code Compliance Department. That is correct. This mini split units it's a new breed. So in the past, we used to see those big square boxes sticking out of the wall or the windows, and these are more viable. They're more aesthetically pleasing, if you will, in my opinion. So the challenge is exactly that. There is a unit that sits outside, and it requires some screening. So should you be inclined to approve the variance, then that will allow the contractor and the property owners to proceed with the permit, and then that will in turn comply with the violation.
Aye, thank you, Mario.
You're very welcome.
Okay.
And just as an aside, this is not the first time mini-split AC units have come before the
That's
ZBA,
correct.
and we are looking at possibly looking at some text amendments because it's more sustainable. It's the future. A lot of these old buildings are replacing with more efficient units, and
Yeah, I think we did approve one a couple of months ago, to do it, and with the shrubbery around it and whatever, you don't even know it's there. It's certainly better than the window shakers, aren't they? Does anyone from the board have any questions of the petitioner? Anyone in the audience against this petition? Anyone for this petition? Public hearing's closed. May I have a motion from the board, please?
I will make a motion that in P&Z case number 2611000004, I move we find there's competent and substantial evidence in the record that all requirements for granting the variance have been met, and they can grant the variance up to the 3 conditions requested by staff. Thank you.
Second.
Moved and seconded. Any discussion? Meredith, please call the roll.
Raphael Katz?
Yes.
Joe Circuzzi?
Yes.
Penny Cutt?
Yes.
Nicole Henniger? Linda Thomas?
Yes.
Charlotte Burry?
Yes.
Thank you all for your service.
Thank you.
Good to see you.
Have a great evening.
You too.
Now, last but not necessarily not least, item number 6 is a variance for 3264 ENH LLC, P&Z number 2611000005. And I'm not even going to mention any names because I'm sure you're not the person on this sheet.
Good evening. My name is Carlos Molgora. That's spelled Molgora. I am the sole member for 3204 PMH LLC, and that is the owner and record for 3204 Southeast 6th Street, Pompano Beach, Florida 33062.
And you have been sworn in.
I have been sworn in.
And are you going to speak, or are you just going to stand there?
Good evening, everybody. My name is Christian Orozco, Orozzo. My address 1400 Northwest 143rd Street, Miami, Florida. I'm the actual contractor, the pool contractor. We're here with my client, with Carlos Morgora.
Okay, and you have been also sworn in.
Yes, ma'am, I have.
Thank you. Mr. Reale.
Thank you. For our final item tonight, the applicant landowner requests a variance from sections 155.3210C, 155.4302B2, and 155.4303GG3DI of the zoning code. The requested variance would allow the construction of a swimming pool within the front yard, located 15 feet from the front lot line, in lieu of the minimum 25-foot front yard setback required by code. The subject property is located on the south side of Southeast 6th Street, between Hibiscus Avenue and South Riverside Drive, on the Barrier Island. The subject property contains a 4-unit residential building constructed in 1951. We actually found that permit, BP 51449. The structure occupies a substantial portion of the central and rear areas of the lot, resulting in limited usable open space. Due to the configuration of the lot and the placement of the existing building, the applicant contends that there is no practical rear yard area available for the installation of a swimming pool in compliance with current code requirements. These conditions are inherent to the site and were created by prior development, not the actions of the current property owner. Strict application of the zoning code would effectively preclude the installation of a swimming pool on the property. Swimming pools are a customary residential accessory use within the city. Staff finds that the requested variance is limited in scope and seeks relief only from setback and locational requirements necessary to allow a reasonable accessory use of the property. The code already permits swimming pools within front yards on corner lots and through lots where similar yard constraints exist. The original development did not include on-site parking, and parking has historically been accommodated within the adjacent public right-of-way. While these spaces are not reserved exclusively for the property, this condition is common among older developments on the Barrier Island. A swimming pool is classified as an accessory structure and does not constitute an expansion of the principal building. Therefore, the proposed improvement does not trigger a requirement to address non-conforming parking under the zoning code. Building permit number 22-7772 approved the installation of 2 green buttonwood trees within the proposed pool area. Relocation or replacement of the affected trees would be required as a condition of approval. Again, there are 8 variance review standards. The applicant has gone and addressed each of these in their narrative, and should the board determine that the applicant has provided competent and substantial evidence sufficient to satisfy those variance review standards, staff recommends the board include the following conditions as part of the order. 1, the applicant shall obtain all necessary governmental permits and approvals, including building and zoning compliance permits. 2, the applicant shall relocate or replace green buttonwood trees that would be displaced by the swimming pool installation in accordance with city requirements. And the 3rd recommended staff condition, the swimming pool shall be installed in substantial conformance to the plans submitted with this application, including setbacks, fencing, and safety features. And that concludes staff's report.
Thank you, Scott. Please go ahead.
Thank you very much. As Mr. Reale says, the shape of the lot and where the building is doesn't allow for any practical site for the pool. We're not trying to build a big pool. It's a relatively small pool. And I think the city has encountered this issue before where the corner lots didn't have a practical site, so you probably had an influx of people here asking for the same thing, which I think prompted the city to change the conditions around that. So it's a very similar case where we, because of the conditions of the lot and the building, again, we can do it. We have absolutely no issue with the conditions from staff, and if you have any questions, I'm more than happy to answer.
Does the board have any questions of the petitioner? Yes, Penny.
What are the dimensions of the pool? I don't see them listed.
The dimensions of the pool is a 20 by 10. Is a 20, long, 10 width.
So I see that the pool is set 19 foot 11 inches, so almost 20 feet off of the residence.
Correct.
And it's only set back from the property line 13 feet. It seems if it were set about 8 feet off the residence, you wouldn't need a variance.
I think the variance is around where the structure is located, as in towards the front. Is that correct, Mr. Reale?
I'm sorry, could you repeat the question?
I think the variance requested is to be able to put it in the front of the building.
Yeah, this is, there are a few things. One says accessory structures can't be in front of a principal structure. There's been debate, this is an L-shaped, so there's been debate in the past, is it still in front of the principal structure if you line it up with the closest facade to Southeast 6th Street? To be on the safe side, we included all of these associated
I'm not
provisions.
questioning the location in front of the structure. I'm questioning the setback from the property line.
She's saying, why can't you move the pool back towards the house so it's not
It
in
seems
the
like if you
variance?
shift the pool so that it's 8 feet off the house, you wouldn't need a variance.
8 feet is not that much.
I mean, even if you shift it 12 feet off the house, you need less of a variance.
What is the variance up front?
I heard it was 25.
15, it's located 15 feet from, proposed to be 15 feet from the front lot line.
So he would go
Drawing shows
10.
13.
Does it?
Yeah. At 13?
Oh, yeah. Go ahead and display.
So he wants to go 12 feet out, is that what it's correct?
The drawing shows that it's 13 feet off the property line and 19 feet 11 inches off the house. So I think it could be shifted to accommodate the 25 feet or at least to substantially reduce the requested variance.
If that is a part of, if that would be made as a condition of us continuing on with the project, we will be agreeable to amend.
I mean, I personally don't object to the location of the swimming pool, given the, physical constraints on the site. I just don't see the justification for the requested 12-foot variance.
We can, again, if the variance around having it where it is accepted, and I would have absolutely no problem putting it back.
What would it be then?
City attorney, if he changes how many feet he wants for the variance, we can't do that tonight, right? He'd have to come back.
Well, this is, this is less restrictive if it were to be pushed back further. So I don't want to speak for you.
No.
I just want the proper answer so that we don't do anything wrong here. Sir?
I want to make sure, because I was confused about what Ms. Cutt was suggesting. It appeared, as I heard you, that you were recommending adjusting by the applicant their own, I call it a site plan for lack of a better word, where they're going to place this pool, and that may eliminate need to request a variance. Was that your intention?
It may eliminate the need to request a variance to that particular code section if we're looking to get a variance from the location of the pool in the front of the house. It would reduce the sections of code that they need a variance from, reduce the number of variances required.
Understood. And so, again, that, going back to development services, then, you still can move forward in this discussion if there are other variances needed, and if the applicant is willing to make the adjustments that have been recommended by Ms. Cutt.
Correct. If the applicant agrees to, as long as it was advertised at 15 feet from the front lot line, if the applicant voluntarily agrees on the record to push it back further away from the front lot line, that's reducing the original ask, so it would not need to come back here. I'd still think a variance is warranted.
It's
because-
warranted, yes.
Yeah,
Because personally, I don't think I would want a pool 8 feet from my house, but if he took the variance, instead of just 15 feet, maybe 20 feet from the front lot line, that would reduce it. They would still need a variance, just for less space.
And just to clarify, the drawing shows it 13 feet from the front lot line, not 15.
Oh, it doesn't? Okay,
So
well,
it's-
they said
it's even
15.
less.
Yeah, but the drawing says 13. So if we vote on this, we're going to vote on it that we approve that the pool to go where in the front with a 20-foot setback as opposed to a 25. Is that correct?
If the applicant is amenable to that, you could change it to 20 feet from the front lot line, and that could.
Is that okay with the petitioner?
We're okay with
If we
that,
do
Madam Chair.
The petitioners
Well,
are
what I
okay?
had mentioned was, they could put the pool 8 feet off the house, not need a variance to that section of the code. The chair suggested 8 feet was a little too close to the house, so maybe grant variance, but less feet than what was requested. Right now, the pool is proposed 13 feet from the front lot line. The code requires 25, so they're requesting a 12-foot variance. Maybe we, reduce that to a 5-foot variance and shift the pool south, because north is down on this drawing.
Now I'm confused.
I understand what you're saying. Move it closer to the house, not so close, not closer to the street.
The portion I'm trying to make sure is clear is for the applicant who is either going to agree to this new condition or not, and then I'm also trying to make sure that from Development Services, that if the board moves forward and moves and seconds this adjustment, is that the only adjustment? Because I'm hearing that there are other components of this variance that must also be addressed.
Well,
We still need to address a variance to allow a pool in front of the house. So if you look at the side setback, they're proposing a distance of 12 foot off the house. So if you shift the pool so that it's only 12 foot off the house, so it's 12 foot and 12 foot, then they only need a 4 foot 1 inch variance instead of a 12-foot variance.
You're saying 12 all the way around?
Yeah.
What about the side? What's the side there? I can't read that.
It's 6'7", but it looks like that's more than
What's it
6
supposed to be?
required.
That's fine, as long as.
That one's good?
Yeah, the side is not an issue, yeah.
So I guess the request is
Shift
to
it south
shift
so
it.
it's 12 feet
It's
off the
12
house.
instead of 19. So it's 7 feet back.
Sir, do you understand what?
I absolutely do, Mr. Saunders.
Okay,
I've been following all along.
That's the critical.
I'm just waiting to see who's going to make this motion and how.
Well, he needs to agree that he wants to do that.
Well, he's saying it's
That's his
okay.
decision.
Madam Chair, I agree to do that.
Okay, we've got that settled. Now, who's going to make the motion? The one who
We're gonna have
brought
to
it
run
out.
Those numbers.
So I'm not sure if my math is here right. It's been a long day. But I
Yeah, what
think
is that, 19 what?
Now it's 1911 off the house, so
Okay.
we want to reduce it to 12 feet. So that gives us a 7 foot 11 that we're adding to the 13. So now we're at 20 foot 11. So we need 4 foot 1 inch, which is what I said before, right?
Correct.
Okay, so I was right before.
High-level math for me.
Yeah, it's too late for me. My calculator's
Okay, I'd like to
broken.
make a motion.
It's 2011. 20.1.
I'd like to make a motion in planning and zoning case 2611000005. I move we find there's competent and substantial evidence in the record that all the requirements for granting the variance have been met, and that we grant the variance subject to the preconditions requested by staff and an adjustment of the location of the pool so that it's 12 feet off of the house on the south side, which requires granting a variance of 4 feet 1 inch from the north property line.
Do I have a second?
Second.
Okay. Any further discussion?
No, ma'am.
Meredith, would you please call the roll?
Penny Cutt,
Yes.
Joe Circusi,
Yes.
Nicole Henniger,
Yes.
Raphael Katz,
Yes.
Linda Thomas,
Yes.
Charlotte Burry.
Yes, your variance has been granted.
Thank you very much. Have a great evening.
Oh, you're very welcome. And
You have to
do we
change
have
it?
any good news or bad news? We don't have any other business tonight. And since we don't, I just want to thank you all for being here. It's been a wonderful evening. Thank you for your time and your dedication to the city of Pompano Beach. And everybody get home safe. Thank you. Meeting
Thank you.
adjourned.